Okay, my number of attendees seem to level off, so I'm going to get started. Good afternoon and welcome to part 3 of the New Hampshire Planners Association virtual spring webinar series. My name is Heather Shank and I'm the city planner for the City of Concord, and I'll be moderating this afternoon's session on housing. On behalf of the NHPA Executive Committee, I want to thank you for taking some time out this afternoon to join us, considering the current circumstances. We know you all may be a little burnt out on the Zoom sessions, as many of us are, and we appreciate everyone taking the time to participate. As many of you know, each year the New Hampshire Planners Association hosts their annual spring conference. The event attracts planning professionals from across New Hampshire and neighboring states, and is an opportunity to showcase New Hampshire's unique communities, discuss relevant topics, and provide success stories and best management practices. This year has been unprecedented, and as a result, NHPA decided to reformat the in-person conference and instead present this series of webinars. Today's the third and final session, following up on the first session, which covered lessons learned from COVID-19, and last week's session, which was on recycling. Though we're all disappointed to be unable to host this year's event in person, we hope that you find the webinar series relevant and applicable to your communities. I want to thank all of our panelists that have participated over the last few weeks, Antioch University and Krista Daniels, our IT support person, Harold Hale, and the conference organizing group for putting this together. We have a great session planned for today, and I'd like to get us started. Let me forward here to our agenda. So I'm going to hand it off to Krista in a moment to go over logistics and sponsors. Then I'll be introducing our speakers who will put on their presentation, after which we'll have a short question and answer period. And then finally we'll close at 3 o'clock with a video of the recipient of our Jeffrey Taylor Lifetime Achievement Award. With that, I will hand it off to you, Krista.
Thank you, Heather. So for a few of you, you've seen this spiel already, but just a few logistics before we get started. If you have a question, a content question that you would like one of the panelists to answer, please write it in the Q&A section and select to all panelists so we can see the questions. If there are any questions that we don't get to at the end by 3 o'clock, we're keeping copies of them, and when all of the webinars get put online at the end, we will also try to answer the questions that we didn't get to. If you're having technical difficulty, please use the chat box and send it to the host, and we'll address or try to address that technical problem with you directly. If you have to jump off or you do have technical problems and can't stay for the whole webinar, just so you know, the presentation will be recorded and posted to the APA Northern New England chapter website in the New Hampshire section, and we're hoping to have them all up in the next week or two. So thank you for that. Next slide, Heather. Sure. So just so you know a little bit about us, I'm sure many of you do, the Center for Climate Preparedness and Community Resilience. You can get to us at that web link, communityresilience-center.org. It's the Climate Center for Antioch University. And our main role is to strengthen communities to prepare, respond, and recover in the face of climate impacts and other disruptions through innovative solutions. And so we like to work directly with communities, especially in New England, to move climate resilience planning forward. Next slide. And then just the last plug-in I'll give is that we do offer a climate resilience certificate, and you can take this. You can either take it just for professional credit and audit, or you can actually take it for credit that could go towards something in the future, or if you've already been working in the academic field. One thing to note is that each course is completely asynchronous, so you can do it within 4 weeks at your own time pretty much. And there are about 1 credit, and this fall we'll have 3 different courses. So in September, there'll be one on climate change uncertainty. In October, there'll be one on planning and vulnerability assessments, which might be really relevant to the work you're doing. And then the last one in November is basically on communication, engagement, and leadership, all related to climate change resilience. And so you can register for just 1 course or the whole series every year, however it fits your schedule. So with that, I will turn it over to Heather for the official webinar part to begin.
Thank you. So our speakers, Before I introduce the speakers, the focus of this webinar is to provide an update of current study that's underway currently by the New Hampshire Housing Finance Authority to review New Hampshire communities' progress towards complying with the state's 10-year-old workforce housing statute. Some municipalities have embraced the challenge while others are, and I quote, hiding under rocks. Other housing initiatives will be discussed as time allows. So now I'd like to introduce our two speakers. We have Marc Fougere. Mr. Fougere is the president of Fougere Planning and Development and is an AICP land use planner with over 29 years of both public and private sector experience. He has an extensive background in project management, dealing with a broad array of planning related issues, including spearheading rezoning efforts, managing development teams, site and land use planning, fiscal impact analysis, public presentations, land use law, and consensus building challenges. Mr. Fougere has also served on a municipal planning board and as a selectman. Mr. Fougere presently provides town planning services to 5 New Hampshire communities. Our other presenter is Ben Frost. Mr. Frost is the Managing Director of Policy and Public Affairs at New Hampshire Housing Finance Authority, where he coordinates legislative initiatives and strategic planning and serves as internal legal counsel. He frequently lectures on issues of affordable and workforce housing, land use law, and ethics. Ben has over 30 years of experience as a land use planner and over 20 years as an attorney. He's a founding member of the Governor Council of Housing Action New Hampshire, which is a low-income housing advocacy organization, and for 10 years served on the New Hampshire Energy Efficiency and Sustainable Energy Board. He lives in Warner, where he serves as chairman of the planning board. With that, I will hand it over to Ben. I'm going to stop my screen share, Ben.
Thanks so much, Heather. It's really a pleasure to be here today talking with some friends, a lot of people who are participating in this webinar, I know, and appreciate the time that you're devoting to this. It's about 10 years ago, in fact, July 1st, 2010, that the workforce housing law went into effect, and it had been worked on for a few years before that. And the legislature gave extra time to municipalities to adopt it before it went into effect in 2010, 2 years after it was passed. So 10 years has gone by now, and we started wondering, well, what has really happened as a result of the workforce housing law? How have communities responded to the law? And we recognized anecdotally that, looking at newspaper accounts and reading through town meeting minutes, looking to see what had been done, we recognized that a lot of communities had made changes to their zoning in particular. And so we had a kind of a tabulation of that, 60 or 70 communities that have done something in response to the workforce housing law. But we didn't make any effort to assess the quality of those efforts. And so with this 10-year anniversary coming up, we decided to hire Marc Fougere to take a look at what some communities have done. So he'll talk about that later. What I'd like to do is to give a kind of a background to the workforce housing law and how it came to be and some of the details that are associated with it, just as kind of a refresher for folks who are familiar with it, and maybe new for those who aren't familiar with it. So let me pull up my screen and share it with you, and get this presentation running. So this is a 10-year retrospective on the workforce housing law. And just a little roadmap for this presentation, talk about a few basics behind the law, and then more generally, and then the background to the workforce housing law itself, details of the law, and then I'll turn it over to Marc for his observations on the study that is underway. I would say nearly complete, and so I think we expect to be publishing that sometime this summer. He's looking at me like, I need more time. So first off, constitutionally, got to recognize that New Hampshire is not a home rule state. It's a Dillon's rule state, meaning that for anything that a municipality wants to do, it has to find a legislative enactment by the legislature granting power to the municipality to do that. So this is basically called enabling legislation. Zoning in New Hampshire municipalities were enabled in the 1920s through the legislature's adoption of the Standard State Zoning Enabling Act. Actually, it was an earlier draft of what was ultimately put forward by the Department of Commerce in, I think, 1926 or 27. The act was adopted in 1925 by the New Hampshire legislature and confirmed as a valid exercise of the police power by the New Hampshire Supreme Court in Sundin versus Rogers, and also by the U.S. Supreme Court in Euclid versus Ambler Realty. This is, I think, really familiar stuff to a lot of people, but may not be fully familiar to everyone. So I read a PlanLink post this week by someone who's served many years on a planning board, and this person who was posting talked about the statutes as guidelines for municipalities. No, they're not guidelines. They may provide some guidance, but they are not guidelines. They are the foundation for all municipal action. Make no mistake about that. So what? What's the issue then? The freedom to zone and to regulate the use of land is not an unlimited power of municipalities. You've got to look to the statutes and also the Constitution. So remember the language used by the U.S. Supreme Court. If a policeman has to know the Constitution, then why not a planner too? Planners do have to be familiar with constitutional law, in particular takings. But there is an awful lot of freedom in exercise of land use controls by municipalities, subject to the strictures of the Constitution, both U.S. and New Hampshire Constitution, and the statutes themselves. The innovative land use controls, you look at RSA 674-21, it has that laundry list of things in it, some of which are fleshed out in great detail, such as inclusionary zoning or impact fees particularly, but it is a laundry list that says including but not limited to, which means you can come up with more things that aren't specifically enumerated in the innovative land use controls that are nonetheless a valid exercise of the municipal police power. So consider, for example, form-based codes. You look at that list of things in RSA 674-21, you will not see form-based codes in there, and yet it is a valid exercise of the police power by the municipality pursuant to the Zoning Enabling Act. So with regard to housing, this freedom it gives municipalities great flexibility to respond to the demands of the housing market, the needs of the population, both within their community and in the surrounding region. But it's also part of the problem, because a lot of communities have over the years used their power to regulate the use of land as a means of excluding certain populations from being able to afford to live in their communities, so-called exclusionary zoning. And here really is the problem statement as expressed by the legislature. This is what I call the hortatory statements of land use by the legislature. They don't have real specifics, but this is in 672.1, there is a list of things dealing with agriculture and agritourism. Mark is very familiar with agritourism, forestry, silviculture, agriculture. So all of those different things, fisheries as well, I think is included in there. There's also this thing dealing with housing. So what it says is that there has to be an opportunity for the development of housing that's affordable to low and moderate income families, and that it shall not be prohibited or unreasonably discouraged by the use of the municipal planning and zoning powers or by unreasonable interpretation of such powers. And that phrase, unreasonable interpretation, does have some further description within 672:1. So take a look at that. I encourage you, just keep that in the back of your mind. This has been the law since the early 80s, when the planning and zoning statutes were all reorganized and recodified.
And Ben, I just want to jump in for a second, if you don't mind, to jump
ahead.
back on that innovative statute, because I think it's an important thing for planners to consider if you're going to adopt, or even if you already adopted a workforce housing statute. That innovative land use statute is a very powerful tool, and one of the most significant powers is it's not appealable to the ZBA for interpretation issues.
Right.
So if
right.
you're going to adopt a regulation, I think it's very important that you cite that statute as a guideline, as a authority statement. I dealt with this situation this past year where there was a lot of opposition to a workforce housing project, not surprisingly. And the gentleman wanted to appeal it to the ZBA, our interpretation, and that's not permitted. I think that's a very important thing for planners to consider if you haven't done it, to include that in the next round of changes. Sorry, go ahead.
Right. And Mark, Mark is going to chime in, provide color commentary during my presentation, and when he's talking, I'll interrupt him too.
Right.
So, in 1991, the New Hampshire Supreme Court decided a case against the town of Chester, and this litigation actually went back to 1979 when a developer was starting to attempt to develop a piece of property in Chester, and it went through various iterations before the planning board. Finally got a decision in 1986 from the planning board denying the application. That got appealed, and 5 years later, finally a decision by the New Hampshire Supreme Court. See how long litigation can take in some cases. In this situation, the New Hampshire Supreme Court, at trial court, this was heard by a judicial master, then the master's decision was confirmed by Superior Court. That was appealed to the Supreme Court. The master at trial found that the entirety of Chester's zoning ordinance was unconstitutional, and the Supreme Court said, well, they backed away from that constitutional cliff and said, let's not do this based on the Constitution, but let's just look at the statute. And the Supreme Court always shies away from doing constitutional interpretations of when it can rely on a statutory interpretation instead, which is a less severe sort of decision. But what they found was that Chester's exercise of its zoning was inconsistent with the zoning enabling statute because it effectively excluded people of lesser means, people of low or moderate income, from being able to afford to move into Chester, to be able to build a house in Chester, or for the developer, as in this case, Remillard, to be able to build apartments that would be affordable to lower income people. It was simply almost impossible for anyone to develop that kind of housing in Chester. And what the Supreme Court said was, you're not just looking at the needs of the people within your own community. You're looking at the needs of the people in the region in which the municipality is situated. So you can't, in the words of the Supreme Court, you can't dig a moat and pull up the drawbridge. You're not an isolated enclave. You have to be responsive to the needs of the region. So when the Supreme Court was interpreting the zoning enabling statute, and there's this word community that appears in that, the Supreme Court said it's not just the land within the four corners of the municipality, but the broader region. That is a municipality's community. The builder's remedy in that case was awarded, meaning the developer didn't have to go back to the planning board for any further action. But then what happened? That was 1991. If anyone was around 1991, you remember what the housing market was like in New Hampshire. It was terrible. So nothing happened for a long time with this property. Ultimately, it was developed. Well, what happened in communities? For the most part, communities said, well, thank God we're not Chester. Yet this is the law of the land. This is the Supreme Court interpreting the law. It should apply equally to all municipalities, but most municipalities were slow in their reaction, if they reacted at all. This is, in fact, the development that was built ultimately on the site in Chester. It is a combination of affordable housing and market rate housing, duplexes and quads. They are, I looked at some sales prices on Zillow from 2019, and they're all, under $300,000. And some of them are not the prettiest things. It's nice that they're hidden by bushes, but they are in a really good location, really easy access to Manchester. And it's an interesting example of conservation subdivision. So you can see there's a lot of conservation land, mostly a portion of it is wetland, but a lot of it is otherwise developable open space. So I think the planning board ultimately did a good job with this, and now the town got something that is a benefit to the town. There's been further litigation regarding workforce housing or low-income housing. This is Great Bridge Properties versus Ossipee. This is a Superior Court case. I think this is in the property, the land Ossipee is in Carroll County, but this was heard by the Stratford County Superior Court. I don't know why. But what was sought was variances because of the highly limiting way in which the zoning ordinance had been written in Ossipee. Multifamily uses were only allowed on water and sewer. You could only have one building per lot, one principal building per lot, and a maximum of 4 dwelling units per building, making it effectively impossible to economically develop affordable housing in Ossipee. And what did the ZBA chairman say at the hearing for the variances? He said, "We know that. That's the whole purpose of the zoning ordinance, is to exclude that kind of development and those kinds of people." So this was, and I know the attorney for the developers, and I talked to him about his reaction at the time when the ZBA chairman was saying that he was happy that he had this as a recording because this transcript was invaluable in their success at trial, and this is what the development looks like. It's a pretty simple, beautiful development in Ossipee, easy access to Route 16, and since it was built, we have not heard any. We have not heard that the town of Ossipee has been ruined, as some people were claiming would happen if these houses were developed. In fact, they're probably some of the better tax-paying properties in the town. So let's move forward to the workforce housing law. 2007, we were approached and the BIA was approached, and we were asked by legislative leadership, are there some things we could do to help improve housing development? And so we gave them a laundry list of 6 different things, both to the House and the Senate. This, through a good year's worth of lawmaking, wound up being the workforce housing law. And what it says is every municipality has to provide a reasonable and realistic opportunity for the development of workforce housing, including rental and multifamily housing. It says that you have to look at the collective impact of all of your land use regulations, meaning you have to take all of your land use regulations, essentially put them in a big heap and see what impact they have in toto on the capacity developer to build this sort of housing. It says that workforce housing has to be allowed in a majority of residentially zoned land area. And so a lot of communities ultimately have come up with these overlays of 51% of their residentially zoned land, and that's consistent with the law. And basically, lot size and density must be reasonable. Some definitions here. These are in the statute. I'm not going to go into these in detail, but it does cover both renter and for purchase workforce housing. The affordability factor, 30%. No more than 30% of a household's income should have to be spent on its housing costs. So that's on the ownership side, it's principal, interest, taxes, and insurance. On the renter side, it's a rent plus utilities or gross rent. And then there's this notion of fair share. And this was it was not necessary to put this into the workforce housing law, but the municipal association, when we were negotiating with them, asked for it, and we said, okay, it doesn't harm anything because it is the law already. And this was going back to Britain versus Chester. Every municipality has to provide its fair share of a region's need for this sort of housing. But within the context of the workforce housing law, the question of fair share came up, and the legislature debated whether there should be numerical standards in the law itself. Harkening back to what the New Hampshire Supreme Court did in 1991 in Britain versus Chester, when it said that it would not adopt quantitative standards, but rather leave it up to a municipality to come up with its own reasonable means of complying with these statutory requirements, the legislature, in response, embodying that sort of reasoning, also said, we're not going to require municipalities to have at least 10% or 15% or 20% of their housing stock as affordable. It's up to them to figure out what that fair share is if they want to. And the only reason anyone really would need to want to identify what their fair share is if they were going to decide that they didn't have to respond to the workforce housing law's requirement. Because if you're providing your fair share, then you don't need to do anything else under the statute. You've already met its obligations. So this is a question for a lot of communities. Appeals, this doesn't really affect planners too much because it's after the planning stuff is done, but just recognize that the burden of proof remains with the developer to demonstrate that a municipality has been unreasonable in its actions. There is an accelerated appeal here for workforce housing, provided that the developer put into writing as part of the application that it was workforce housing, thereby alerting the local land use board that the workforce housing law was coming into play in this particular application before it. So 6 months to a hearing on the merits. If the builder's remedy is applied, and it's a rare remedy applied by the courts, but if it is applied, then it has to include long-term affordability restrictions, which a town can do anyway. A planning board can impose long-term affordability restrictions on developments. Here's just a couple of examples of what we would call workforce housing. This is the Squamscott block in Exeter. This is an infill development. It had been a surface parking lot, but you can see how well it fits into the historical character. You've got the National Register of Historic Places listed Exeter Town Hall just beyond. You got Citizens Bank in the front. This had been a Citizens Bank parking lot. And you wonder, well, where do people park now? Well, those people who are walking on the sidewalk are walking in front of the entrance to the parking structure that's integrated into this building. They actually tripled the number of parking spaces by building this. This was actually built before the workforce housing law was law, but it is regarded as workforce housing by the town. Accessory dwelling units in the news more recently with the 2016 enactment of the ADU law, but it's an easy way for municipalities to help provide some level of workforce housing, although you cannot put rent restrictions on ADUs unless they are part of some sort of bonus that you're doing through your zoning ordinance. Remember that the ADU law requires municipalities to allow at least one accessory dwelling unit detached in any residentially zoned area. And where is the ADU? It's right there. Pretty neatly hidden. Other things, adaptive reuse. Roger Hawk took this picture a number of years ago and sent it to me. This is a converted farmhouse in Hopkinton. It's pretty beautiful. I don't know how many units are there. I mean, 5 or 6, I think, but it looks really good. And this is not something that the town was trying to do. It's just the owner was able to do it under what the zoning was at the time. And then another adaptive reuse, the Bellamy Mill in Dover, which is a low-income housing tax credit project that New Hampshire Housing financed. Exeter was really a leader in inclusionary zoning in New Hampshire, and the Watson Woods and Forest Ridge development was built under that. Watson Woods is the affordable portion of this overall development, and these are all condos, and they maintain their affordability restrictions. And then just as a demonstration that you can do things really nicely, this is Hidden Pond, which is in Amherst's historic district. It went through the Historic District Commission for permission, and this is another picture of that development. And then finally, we'll wind up with 2 slides in Bedford. Bow Lane in Bedford, this is a development that recently got approval from the Bedford Planning Board, but it was the subject of enormous controversy in Bedford. And Mark can talk a little bit more about that. But if you look, and this is, the site is next to the high school in Bedford, right off of 101. But if you compare it to another one that was developed in Bedford, same developer, same architect, same design, same zoning ordinance, no controversy. Why is that? Well, we'll let Mark figure that one out. So I'm going to turn this over to Mark now. We're at the 10th anniversary. We wanted to know what's happened, what have municipalities done, what are some of the lessons learned. So we hired him to answer those questions and to ask a few more. Mark, take it over.
Well, thank you, Ben. Hello, everyone, and welcome to the broadcast today. Hope you're all doing well out in Coronaville. I worked with Ben and a group of consultants that I put together when we wrote the Workforce Housing Guidebook 10 years ago when after the law got adopted to provide some opportunities for, or some guidance for communities to how you're going to implement this thing. And it's, I want to thank New Hampshire Housing for reaching out to us to take another look at it and see what's happened over the last 10 years. Working with me on this project is Karen White. Many of you may have remembered her as the planning director in the town of Bedford for many years. And Steve Keach from Keach Nordstrom is also providing us some assistance. So our task was to take a look across the state of how communities are dealing with the workforce housing statute over the last 10 years, you know, the good, the bad, the ugly, success stories, nightmares, etc. Working with New Hampshire Housing, we developed a list of some 30 communities that we looked at, and we did profiles of those, looking at what was adopted, getting some stories from local people, our towns, chairmen, planning boards, our staff. And then based on that list, we cut it down to 10 communities that we're going to be doing a deeper dive into, and we've just started that analysis at this point. So we are seeing some trends and have some thoughts that we've discovered along the way so far, and we'll share some of those with you today, talking with people around the state. And we're still researching, and I'm sure when we get into more discussions with people, we'll find some more stories. I was talking with a developer yesterday who shared some stories of his woes, and I wasn't surprised by what I heard. So, you know, not surprisingly, some communities in New Hampshire took to task the ordinance and tried to do their best and adopted the statutes necessary, ordinances necessary to amend their regulations to allow workforce housing, and complied with the law as the best they could. Others, not surprisingly, have ignored it or have done a poor job in our estimation of what was adopted. And that's not surprising. I think one of the blessings of when the statute was adopted 10 years ago was we were in a very deep recession, and it gave communities many years to get their act together, to try to be proactive with this new law, and had plenty of time to get into compliance. So if communities aren't in compliance now, there's really no excuse. It's been over 10 years. And Ben didn't bring it up, but it should be discussed. And if you haven't heard about it, the town of Wyndham was one of those communities where actually the planning board tried to do the right thing by adopting a regulation in that community. If you're familiar with Wyndham, it's along the southern tier off of 93, not far from next to Salem. But the voters felt differently. And for whatever reason, the voters said no 2 or 3 years in a row to adopt the workforce housing ordinance. So unfortunately for the town, the developer decided that he wanted to build a development, brought it to the planning board. They said, well, we're sorry, we have nothing on our books to allow such a project to go through. Go to the ZBA, which he did. The ZBA said, well, you don't have grounds for a variance, and denied him. So they went to court. And unfortunately for the town of Wyndham, the judge approved the plan, which is what happened. And there was 5 duplex condominiums that were approved by the judge, with final details to be reviewed and approved by the local planning board. So for those communities that think that a builder's remedy can't happen, it can, and there may be some other cases that Ben can highlight later on, that if you ignore the law and don't follow the statute, there are ramifications. And in the communities I work in, I've been trying to tell the planning board members and townsfolks that, you know, it's better to be proactive and steer the ship yourself versus having a judge decide it for you, which usually isn't the best way to do planning, or good planning in our state. We've found some communities have adopted regulations, but it's really in name only. If you look under the cover, if you look under the hood, it's really a false approval of an ordinance as far as being able to get to reasonable and realistic expectation of an affordable housing unit. Either the criteria is erroneous, or they're weak, There's a lot of arbitrary stipulations or criteria in the regulations where it's clear that, unless the planning board members like the project specifically, there's a lot of room for denying the project. And that's going to be a problem for those communities. We're working, I was working this past fall in a community where they hadn't really adopted anything. I wasn't there to talk about housing. It was actually another project, but it kept coming up. And I mentioned to them the Wyndham case, which they weren't aware of, and the fact that, it's best to be proactive and you shouldn't be waiting any longer. It's been over 10 years. They rushed together some zoning for town meeting and got it passed, but it only dealt with multifamily zoning. I think 3 of the 4 parcels are presently zoned industrial. One of them is owned by the state, and they didn't touch anything else in their community. So they were very happy that it passed the town meeting, the vote, but they're still not in compliance with statute, and they're still open to being sued. And I think if that was to happen in that particular community, they would lose, which again is not a good thing. We found that not only there's been a lot of adoption of workforce housing across the state in small towns like Jackson, Lancaster, New London, and Rindge, and wealthy towns have took up the mantle also: Hollis, Bedford, Londonderry, and Wyndham. Ben just mentioned the Bow Lane project, and I've been involved in a few of the workforce housing developments that were approved in Bedford. The Bow Lane project was in a very open area, very visible area in the community. It was the second project of the developer in town. The first project was in a mixed-use development on the edge of a commercial area, a much larger piece of property, and it went through with a lot of more ease and without a lot of controversy. The Bow Lane was in a former historic district. It was next to the high school, and needless to say, it ended up exploding across social media with a lot of controversy. It did ultimately get approved, and he may be actually breaking ground in the next month or so. But the results of that, there were some petition zoning changes that occurred that the planning board did not support. I'm going to talk about this a little bit later, but ultimately those petition zoning articles got passed, which is a danger that can occur in this environment. Workforce housing in some cases, as us planners know, can be extremely controversial. We have seen some interesting ideas to address workforce housing, including converting old farmhouses into multifamily units, no density provisions in downtown areas, and a transfer of development rights applying to industrial zones that can accumulate housing rights and then sell off and add density to the receiving areas. So you're getting economic development initiative and housing at the same time. Very innovative, and we're going to be highlighting that ordinance in our report to New Hampshire Housing. Finding a management entity of who's going to monitor the workforce housing units that are built is a very important provision. It's something that if you haven't done, you should look into immediately. Find out if there's a nonprofit affordable housing group near you, such as NeighborWorks, which is what we used. The developer in Hollis used as a monitoring agent. Most communities in New Hampshire don't have the staff, the housing staff with the expertise to deal with that. And you don't want to wait until an application's before you to find someone that's qualified. You want someone that's been around for a while, and look around as best you can. New Hampshire Housing Finance Authority also does that. I think one of our recommendations is that they broaden that outreach ability, because they are a statewide organization. Some areas of the state have more options than others. I know up in the mountain areas of our state, there's been some challenges in finding monitoring agents up there. But it's a very important provision to have. There's a community in the state that had hired an out-of-state company to do the monitoring. This is for a project that's over 10 years old, and unfortunately that company ended up going out of business. and nobody was monitoring the units. And some of those units were sold at market rate. Unfortunately, they were being rented out to people who don't qualify for the housing units based on their income. So it's very important that if you're going to go through the ordinance, go through the challenges of having a workforce project constructed in your community, that those affordable housing units should obviously stay there for a long time and be rented or sold to qualifying individuals. So staying on top of that is a very
Mark, can I just jump in on
Absolutely.
this? I want to underscore the importance of what Mark is saying and having a third party do the monitoring for you, whether it is units for sale or units for rent. And there are a couple of reasons for this. One, this is not the planner's bailiwick. It's not something that planners have much, or in most cases, any experience dealing with that is qualifying people to rent or purchase a unit. It is a fairly specialized field. So if you're trying to do it and you screw it up, you really screw it up badly. As the town that Mark was referring to, it not only did that town hire a firm that went out of business, but they wrote that firm into the deed restrictions. And
specifically
so who's going to be monitoring
firm.
that? Yes, specifically naming that firm as in the deed restrictions itself. And in speaking with some of the town staff more recently, the building department was saying, well, no, this isn't our responsibility. This is a private market covenant. It's a covenant on the property, but it is imposed by the planning board as a condition of the approval. And it's something that the town has an interest in. Another reason why municipalities don't want to be handling this sort of stuff, qualifying purchasers or renters, is that you're dealing with confidential personal financial information, including things like social security numbers, which if you release those publicly, it's a federal crime. You don't want to be messing around with that. So hire a firm that is qualified to do it. New Hampshire Housing has for years said that we would monitor those restrictions provided the municipality used our model. And I know what Mark is saying. He wants us to broaden it out. That's a bit of work to do, because if each municipality is designing restrictions that are different, it becomes very difficult for a broadly based monitor to do that work. But it's something we would consider.
Good. Yep. So needless to say, that's a very important point. And I think this next issue has to do with how you adopt your ordinance and where uses are allowed. Obviously, workforce housing comes in many forms: single family, duplexes, multifamily. Needless to say, multifamily is the most controversial type of workforce housing project you're going to find. I've seen it personally and have the scars to show you. And so I think it's very important that if you're going to create new zones for multifamily and allow workforce housing in those areas, that you do it very, very carefully. You pick an area or community where it makes sense. I know it's important that you comply with the law, but the ramifications of making bad choices of where that zone is can be astronomical. I was involved in a case where my client was proposing a significant amount of multifamily garden-style buildings. It was in the proper zone. It was passed at town meeting. It met all the rules, but it wasn't in the best area for garden-style buildings. There were some multifamilies in the neighborhood, but they were more like 8-plexes, 10-plexes, not 34-unit buildings, which is what the ordinance allowed, the density allowed, et cetera. It created an extreme blowback during the approval process. We were successful in getting that project approved. It's actually under construction right now, and actually has 19 school-age children living in it. I just got a report from the town the other day. But it led to some major changes in their workforce housing law. There was a significant political pushback because of our project. There was major changes, major rewrites of their zoning ordinance as a result of that. And there hasn't been another project approved in the community since. We haven't done a full analysis of the law to see if it's still in compliance, but needless to say, it was because of that blowback that the changes occurred, and that's happened in other communities. It happened in Bedford that we were just referring to by petition, and it happened in a community, the town of Hollis, where I am a consultant. So you have to be very careful. Obviously, you put it where you think it's best, and it is what it is, but it's important to think ahead and plan properly. We are planners, and you should give that quite a bit of thought. Another major issue that we're seeing is social media, which isn't a surprise, but these chat groups start up with information that's often not true, misleading. Workforce housing is becoming a dirty word in many communities. Low-income housing, it's welfare people, it's all the things you hear. We don't want those people here. They're going to ruin our schools. All the nonsense you hear, but a lot of these chat rooms are closed, and it's hard to counter every conversation that's going on. But I think it's important for planners and for planning boards to be proactive as best you can. Be prepared for that. Have someone looking out in the community to see what the chats are going on, and try to counter it the best you can. I know it's a lot of work, and along with everything else we do as planners, but letting that stuff stew and grow can really be detrimental and lead to an ordinance that that gets adopted that's not compliant with state statute, and again end up like the town of Wyndham with the judge deciding approvals. So it's a tough issue, not only for this matter, but all matters these days. We're also seeing a concern from some communities about the HUD criteria that's in the statute. Obviously, that sets up area by HUD. The state's divided into different areas, and depending on what area you're in, the median income is determined, which drives the price point for rental properties and for purchase properties. Some communities are wealthier communities that are in a lower income HUD zone. So the developers having to have lower rents to meet the criteria in a community that has very high property values. So sometimes there's a challenge there to meet the price point in those communities versus others. I've heard that brought up a few times. So there's still work to be done. Some communities have refused to meet the workforce housing requirements with many excuses that it's not our problem. It's a state issue. Land is too expensive, and we just can't make it work. It's workforce housing is always a challenge. I do a lot of work in Massachusetts doing fiscal impact reports for 40B developments. 40B is the workforce housing law in Massachusetts, which actually requires a 10%, at least 10% of the community's housing stock to be workforce, and it works down there. And if you can build affordable housing in Wellesley and Lexington and other communities in 128 with some of the most highest land values in New England, you can do it here in New Hampshire. So it's easy to make excuses. Workforce housing is very, very important for our state, for our economy. It'll be interesting to see what this crisis does to the housing prices, but what I've seen right now, it hasn't dipped at all. If we're going to have a strong workforce here, strong businesses, we need places for people to live. So hopefully just keep fighting for workforce housing, and I think we're going to open it up for Q&A at this point, Ben.
Yeah. We are ready for your questions. I know there are some out there.
Yes, thank you. I have a whole bunch of questions here, and I'm just going to start from the beginning. I think you did answer some of them, but I'll just read through them. One of OSSAP's defenses was that it meets its share of affordable housing because it has so many mobile homes. Can you speak to the issue of a municipality's share and the role of manufactured housing?
Well, manufactured housing is an affordable housing option for a lot of people, especially in New Hampshire, because under New Hampshire law, manufactured housing that's truly not just trailers or tiny homes, but true manufactured housing that meets the HUD construction standards adopted in 1974, if it meets that definition, those construction standards, then under New Hampshire law, it is treated as real property, which is unusual across the nation. Most states don't treat manufactured housing as real property. What that means is you can get a mortgage on manufactured housing, which reduces your borrowing costs a lot. So it makes it even more affordable in New Hampshire than it is in other places. So yes, manufactured housing, I think, is an important part of the work, for any community to meet its workforce housing challenge, if you will. If you're looking to demonstrate that your community meets its fair share, you would be counting, in all likelihood, manufactured housing units in that analysis.
I think to that point, just to follow up also is you need to have a cross section of housing, not just owner occupied or manufacturing. You need rental housing also. So I think that's where the community got into a snag.
Our next question is the no appeal of an ILU ordinance to the ZBA. Are you both in agreement on this point? Has the process been tested in court? Some towns are on the fence and still allowing a ZBA administrative appeal despite RSA 676.5.3 based on town attorney advice.
It was certainly vetted in my community that I worked in. Attorney Drescher, who's been a land use attorney in New Hampshire for over 50 years. He's probably one of the best land use attorneys in the state. Yeah. Was definitive in his defense of that. And that's one of the reasons why we adopted it in the communities that I represent, because of that strong provision. So there's no question about it. Ben may know about any lawsuits relative to it, but you don't want the ZBA or someone having the ability to start interpreting things the way they want it interpreted, or claiming the planning board made interpretations during the process. It's that type of tool, and that's how it should be dealt with. But I'm not aware of any lawsuits on it. Ben may have that.
Yeah, I don't know that this issue has been litigated in any case. The law that cited here, RSA 676:5 Roman 3, has some nuances to it. So read it carefully. Look at, each word has meaning. Read the sentences carefully. And what it talks about is planning board decisions that interpret an innovative land use control. So where that authority has been delegated by the local legislative body to the planning board, then the decisions of the planning board under that are not appealable to the ZBA. The statute is very clear about that. Now, in the particular case, the town attorney may be basing that advice on a particular nuance to that statute, and the attorney's interpretation may well be right. But in the abstract, without any facts before us, if a planning board is making a decision under an innovative land use control, you don't go to the ZBA. The ZBA, it's not a choice. The ZBA does not have what's known as subject matter jurisdiction. It cannot legally take that appeal, and it should not. And if the town powers insist on making someone go to the ZBA, they could be charged with an abusive process and wind up paying court costs and attorney's fees on an appeal. It's a dangerous ground to be treading.
And just in the community I was dealing with, that appeal was heard by the ZBA in the sense that they listened to the argument and then rejected it, citing the statute and that they didn't have authority. So I think
the right decision.
Yeah.
So our next question, is it true that the burden to prove that communities are not allowing a reasonable and realistic opportunity falls upon the developer? And until that assessment is funded by a developer, it may not be clear whether or not a community's regulations provide reasonable and realistic opportunity.
I think it's the community's responsibility. Absolutely. No, it's not the developers. It's the community's responsibility to assess their housing stock and make a determination if they are allowing reasonable and realistic opportunities. And if they're going to take a proactive defense, they can certainly do that. I live in the town of Milford, and planners and the planning board made a determination years ago that we're in full compliance. and therefore didn't have to adopt an ordinance to deal with it. So if your community is on the fence, you have to do the research and have that research available to prove that, in your opinion, that you are provide realistic opportunities, or you've already met your regional fair share need. But it's not the developer's job, it's the town's. Ben, you concur with that?
I agree. I agree completely. I know, and we've seen some ordinances where it's essentially structured to say to a developer, prove to us, the planning board, that we have to let you do this. Now, the developer is not in that position. The statute tells the municipality that they have to do it, unless they can demonstrate that they don't need to, whether they've already done zoning measures, as Mark says, or they can demonstrate fair share.
Okay, our next question is, can't the housing needs assessment process that is required to be undertaken by regional planning commissions under our RSA 3647 Roman 2 be a way to determine each municipality's obligation to meet affordable housing targets?
Yeah, absolutely. So the statute requires the RPCs to do a regional housing needs assessment every 5 years, and that's a statutory requirement. They have to do it. The state doesn't give them any money to do that, but that's a different issue. And so it's an obligation to do the regional assessment. But there's nothing in that that says that the RPC has to do a fair share allocation. Some do, some don't. It is, I think, a useful vehicle for that, and is helpful to some communities as they choose to grapple with the question of fair share.
It's a very challenging study for the regional planning commissions too. I feel sorry for them because, you know, obviously they get their funding by the local communities, and now they're doing a study that might show a community, like was done recently on a nearby community, that they're negative 350 units in the hole. So it's they can get a lot of flack for doing it, especially if one of the communities or a number of the communities show a significant negative result. So, but that's certainly, that analysis is certainly one of the blocks you need to look at. Certainly, yeah.
So are there examples of towns that have imposed affordability requirements on a project based on the workforce housing law?
Yeah, actually, Mark, you want to mention any that you've come across?
Can you read the question again? That forced?
Are there examples of towns that have imposed affordability requirements on a project based on the law?
Imposed.
Well, hasn't Hollis?
Not imposed, no.
Well, but as a condition of approval.
Yeah.
Well, I guess if for example, in the town of Hollis, we have an overlay, multifamily overlay zone. So you're welcome to build whatever is allowed under the zoning in that area today. But if you want to do a multifamily development, it has to be workforce, and then a percentage of those units obviously will be workforce. It doesn't have to be 100%. 25% will have to be workforce, and those will have to be workforce for a period of 30 years. But I'm not aware of a community that most times if you want the density that's allowed in the ordinance, they have to be workforce. So I guess that's how most.
But I guess the question is, how does a municipality guarantee that say they do it at inclusionary zoning, they give a density bonus? How does the municipality guarantee that the targeted units remain targeted? And that's through the use of a long-term affordability covenant. My colleague George Regan texted me, Portsmouth has, and indeed Portsmouth does impose that on its inclusionary developments.
Yes.
I wouldn't necessarily use Portsmouth's covenant as a model, however, because it has some provisions in it that don't really work in the housing market, such as if the property goes through foreclosure, then and under the Portsmouth conditions, then the affordability restriction remains. Such provisions, if they survive foreclosure, they are very unlikely to be the benefits have the benefits of the secondary lending market, meaning Fannie Mae, Freddie Mac, FHA. You're not going to get lending, which is almost every thing that is done in the country for mortgage lending is done through those types of institutions. You're not going to get those sorts of mortgages with that kind of a restriction. The affordability restrictions should be extinguished on foreclosure.
Yeah, having covenants is vital to make sure those units remain affordable for at least 30 years, if not longer. So,
so we're at 3 o'clock, but our video, our award video is pretty short. We could do a few more questions, or we have a lot more questions. We're not going to get through them all. I guess I'll ask Ben and Mark. What do you think we should do a few more questions, or?
If you got a really good question, but
I think a lot of them are great. I think a lot of them are good questions.
we appreciate it very much. This is awesome.
Yeah, no. Well, one question that I sort of had, and it was echoed by someone in here, was about low-income housing, and my question was like the difference between workforce and affordable and low-income housing, and how those apply to the statute. And this person's saying some people can't even afford the workforce housing. What's help for the low-income folks?
Well, I guess the statute, the low income is covered by apartments. That is considered low income. That's in there now. One of the things that I've seen, to be honest with you, is right now we're at 60% for rental and 100% for owner occupied, and given our economy, I don't consider a $360,000 house affordable, which is what in some parts of the state are there. And for low income, you're right, it can be an issue. It certainly, low income owner occupied is not touched in the statute, but it's really, to go into even deeper, you typically need to get some sort of subsidies or lending, favorable lending money to get to below 60% to help bring that number down below 60.
Yeah, I think that's true. I think you look at the definitions. So workforce housing in New Hampshire has a specific definition. Affordable housing, low-income housing don't have specific definitions. These are more based on funding programs or perceptions. Really just rely on what we have in the workforce housing statute to guide your actions. The fact is that the 60% targeting for the rental under the workforce housing law is consistent with financing programs such as the low-income housing tax credit, which developers use to build housing. But municipalities should not expect that a project will be financed publicly with some sort of public benefit, whether it's CDBG or home or the low-income housing tax credit. If a municipality is dealing with an application for workforce housing, or it is structuring its ordinances to accommodate the development of workforce housing, it can't say, well, this will work only with, say, low-income housing tax credits. The municipality has to design its ordinance to allow for the development of housing that is purely financed by private market sources. And that tends to be more expensive, which means the municipality is going to have to provide greater density of units for a developer to economically build a project.
We should probably end it there. I know we were talking before the session started that we would collect any unanswered questions and
Yep.
post it later. We do have some other business that I know Krista wanted to get to. I want to thank everybody, obviously, for joining today, and Ben and I will answer the questions, we promise.
We will. And I want to thank Mark for doing this work for New Hampshire Housing. We really appreciate his expertise and the enthusiasm he has brought to it.
Great. Ben, can you stop screen sharing, and I'll bring up.
I will stop screen sharing.
Great. And now I will bring up the rest of this. Okay. Next, we have our awards section. I want to first, hold on, let me make sure we get to the right screen here. All right, New Hampshire Planners Association Annual Awards. I want to first thank all those that submitted nominations and congratulate all the nominees. Our last award is the Jeffrey Taylor Lifetime Achievement Award. The Jeffrey Taylor Lifetime Achievement Award is awarded annually to an individual who has shown outstanding contributions throughout their career and dedication to the field of planning. This year's award winner has clearly demonstrated this across 5 decades of commitment to every aspect of the planning profession, as is evidenced by the, I'm sure, very truncated summary of his work and accomplishments in the nomination form, and also the overwhelming respect and admiration that came across from his staff who nominated him and that he worked with for many years. So I'm happy to announce that the 2020 Jeffrey Taylor Lifetime Achievement Award goes to Roger Houston. And I do have a video clip to share, if I can get it to play.
I'm honored to receive the Jeff Taylor Lifetime Achievement Award. I knew and respected Jeff Taylor's work, and I'm humbled to receive this. I thank the NHPA Executive Board and the Nominating Committee. I also want to thank the entire planning department who submitted me for this award. Thank you, Linda McGee, Carter Falk, Chris Weber, Marsha Wilkins, Scott McPhee, and Kate Boyer for your support over many years. It was a privilege to work with you. I started my 50-year planning career at the University of Illinois, followed by a master's degree at Glasgow University in Scotland. My first public job was in Scotland designing Erskine Newtown. Again, my sincerest thanks for this award.
Okay, was there a glitch there? Did everyone get to hear the video?
The audio cut out about halfway through.
Because I put it on mute. Should I play it again because it was only 2 minutes? I'm not sure how much I'm not sure how much you missed. All right, let's try that one more time. I did not realize that if I muted myself that you would not hear the video. Okay, I apologize.
I'm honored to receive the Jeff Taylor Lifetime Achievement Award. I knew and respected Jeff Taylor's work, and I'm humbled to receive this. I thank the NHPA Executive Board and the Nominating Committee. I also want to thank the entire planning department who submitted me for this award. Thank you, Linda McGee, Carter Falk, Chris Weber, Marsha Wilkins, Scott McPhee, and Kate Boyer for your support over many years. It was a privilege to work with you. I started my 50-year planning career at the University of Illinois, followed by a master's degree at Glasgow University in Scotland. My first public job was in Scotland designing Erskine Newtown, a new community focused on people, not cars. I then worked as a planner in Colorado for a decade. There was never a dull moment in my 30 years with the Nashua Planning Department. Nashua added over 2 million square feet of retail space, which required alleviating traffic issues on the major roads and public cross-access easements between the sites. We completed several area master plans and a major update to the citywide master plan, which has lasted for 20 years. We also completed a major update to our land use code and reviewed numerous site plans and variances. We added conservation land and built rail trails, conservation trails, secured easements, and built sections of the downtown Riverwalk, utilizing private-public partnerships and public and grant funding. In reflecting on my career, what satisfied me the most was watching people enjoy the places that we as planners help make possible. There was nothing more gratifying to me than to see a young kid learning how to ride a bike on a safe bike path. It's been very rewarding for me to work with so many great professionals, and I was lucky to have great mentors early in my career. And I've always strived to serve as a mentor to other planters. Again, my sincerest thanks for this award.
Okay, sorry everybody. I seem to have had some technical difficulties there. I didn't realize I needed to share all over again. With that, I will go back. So I'd like to thank you all again for joining us. Special thanks to all of our panelists, as well as Mark Fougere and Ben Frost, Antioch University, and Krista Daniels, and our IT support, Harold Hale, the conference organizing group, for putting all of this together. Thank you all, and enjoy.